So have you ever thought about buying or selling a house right here in the state of Texas? Watch this video because we're going to talk about the 1 to 4 family contract. Hi, I'm Keith Milkowitz with Lex Residential Group right here in Austin, and I'm sitting here with Alan Ceshker, attorney at law and founder of the Ceshker Group, the title company, which is in Austin and all over the state. I want him to help us walk through the 1 to 4 family contract, which is the gold standard for getting houses bought and sold here in the state of Texas. So Alan, will you help me out with this?
You bet, you bet.
Let's start with number 3. Section number 3 really talks about what's this house going to trade for? What do we need to know about inputting information about the sale price?
So the most important thing I think on paragraph 3 is if you have a third-party lender, you need to make sure you're putting that, checking off that box, third-party lender, and then go and fill out that third-party lender addendum. A cash purchase is you're putting cash on 3A. If you're doing a creative finance purchase, subject to or wrap, that's a different story. You're adding some stuff into special provisions, but that third-party finance addendum is key. Without that, seller's going to be able to terminate for lack of that information in there.
So that's the great guide to tell you this is how much the house is going to trade for, this is how much the down payment is going to be, or it's going to be an assumed loan, or it's going to be a cash offer.
Yep.
So let's go to the next section, which is section 4, which talks about leases. There's a lot of different types of leases, land leases and other leases that are involved with the house, and it's the responsibility of the listing agent and the seller to talk about that. Tell me a little bit more what's important about leases.
So if the property's rented out, seller needs to advise on that. At that stage, it's really the buyer's obligation to say, hey, I want a copy of that lease. Seller doesn't give a copy of that lease, and that's going to be a reason for the buyer to terminate. The big one that the TREC 1 to 4 contract actually calls out is your mineral leases. The seller needs to provide that information, and the TREC 1 to 4 contract says if not provided in 3 days from effective date, buyer can terminate. So it's a little bit more strict on the mineral leases.
Right, so that's a very important factor. It's very important to know and understand that mineral leases and anything that needs to be, particularly with land, explained within a time period, but other leases that are kind of, I guess, passed over, solar panels, for example, security systems, sometimes it's utility like a propane tank that they've leased. So make sure that the listing agent and the seller really explains what those leases are so you convey them to the buyer ahead of time. Let's go to section 5, which is really important because it talks about earnest money and option money. Let's define what does earnest money and option money use for.
So earnest money is kind of your guarantee that you're going to complete the contract. So buyer's going to put down X dollars for earnest money, and if they breach, seller will keep those dollars. If the seller breach, those dollars go back over to the buyer. As opposed to the option fee, that's really a fee that allows you to have a due diligence period, an option period. And you've got X number of days to conduct that due diligence, and then after that time period, that option fee is going to go over to the seller, usually used as part of the purchase price. But it is going to give that buyer the right to terminate at any point in time during that option period that you've paid for.
Okay, so the option period is really negotiable on the contract, but the delivery of those funds for earnest money and option money, they're defined as what we call time is of the essence. So explain what that means to each party.
So time is of the essence. I call it the magic legal words. It means that if you're 1 minute late on that obligation, then you're in breach. As opposed to if the contract does not have time is of the essence, you have a little bit of leeway. You can have an excuse as to why it didn't occur at the exact time, and the court's probably going to accept that. Time is of the essence means there's no leeway whatsoever.
Okay, and this section has that, so be very careful about that. Let's go to section 6, which we talk about exception docs. So when title commitment and the docs that are required for title to deliver, explain the importance of that for the buyer and the seller.
So when you get your title commitment, your title report, there's going to be some exception documents, deeds, restrictions, covenants, all of those items. Those need to be provided over to the buyer, and if not provided, the buyer can again terminate the contract once those documents are provided. So you got to make sure your title company is really on their game, providing all those Schedule B documents, in addition to the survey when it comes in. Once that survey comes in, buyer's going to have X days they can object and terminate. So you got to be very, very careful on your exception documents, making sure they get there timely.
And that's going to be a requirement of the title company to deliver based on when the contract was delivered to title. The section 6D talks about objections. So once title gets those documents, they get them over to the buyer. And on the contract, there's a certain number of days that are negotiable for them to decide whether or not how long they're going to review those documents. Is that correct?
Yep.
All right, statutory tax and utility districts. What's important about section 6E?
So this has been kind of a confusing area for real estate agents, mainly a MUD notice, for example. We'll talk about MUD notices. At time of contracting, a seller needs to provide that MUD notice. If not provided, again, once provided, is going to allow the buyer to terminate that contract. A lot of agents will rely on the title office to get that document out. Title office will at time of closing. And so if you wait until time of closing, again, buyer's going to be able to object at time of closing and terminate that contract, get their earnest money back. So it's something that a real estate agent needs to learn how to find it, print it out, get it signed at time of contracting.
Right, and they're relying a lot on the title companies, but ultimately it's the responsibility of the sellers and their listing agent to make sure that that's out there. Okay, Alan, so we've gotten past the exceptions and the objections, and we're moving forward to closing. 7A is very important because it tells us what?
So 7A kind of evolved because we had a situation, seller moves out and they cut off the utilities. Buyer says, well, I need to go over there and make sure the dishwasher's working and make sure the air conditioner's working. So there's a bunch of arguments, so they clarified it and said under 7A, seller shall keep the utilities on. So if they fail to, then the buyer can terminate the contract.
And then it's important because sometimes closing is extended at the last minute, so there may be days. So it's important for the buyer and the seller to constantly communicate on exactly when that close date is and ensure that those utilities are on after closing. Okay, let's talk about 7B2, the seller's disclosure notice. This is an extremely important document because it tells the buyer everything that the owner of that property knows about that property. Tell us why this is very important to everybody.
So the seller's disclosure is probably top 3 most important documents involved in a transaction because it's going to essentially tell the buyer, here's the status of everything in regard to the property, if there's been foundation work, roof work, what have you. But the reason it's important is a failure to list it on the seller's disclosure is going to be a very, very bad lawsuit that you're going to face. And I always say the seller's disclosure is a minimum bar. If there's something that you know about the property that a buyer would probably want to know, go ahead and disclose, even though not required in that seller's disclosure.
Yeah, there's a lot of reasons why people don't think that they should, like a fence that may be put over the boundary line of their property, that needs to be disclosed. Or I had a small little leak that caused a spot in my ceiling and I replaced the sheetrock there, that should be disclosed. But my rule of thumb is if there's ever a question whether you should or should not disclose, disclose. It's better to over disclose than under disclose and be caught with your problems later on down the road, correct?
Yeah, absolutely, over disclose.
Over disclose, okay. And that, for purposes of detail, this is the one document that lives in perpetuity, correct? Which means after the sale closes what?
Yeah, that's a good point. In the contract, in the TREC 1-4 contract, it states specifically that after closing, all of these representations still continue, and including your verbal representations will continue in regard to the status of the property. Everything else is merged into your closing documents that you're going to sign at time of closing, but that seller's disclosure is not merged in, it continues on.
Okay, so very important to make sure that that's accurate and complete. Section 7E talks about lender to require repairs and treatments, and then also Section 7F talks about repairs and treatments. Let's walk through what does all that mean?
So 7 is talking about your lender comes along and says, I need repair A, B, and C completed. Again, there were arguments in regard to, okay, who's going to pay for this, who's going to do it, and what 7 did was came along and said, if the repairs aren't completed by either party, whichever one, then the contract terminates. And so it kind of fixed that problem that existed for a while.
And most of the time that's for government-backed loans like VA and FHA loans, correct?
Exactly.
Not usually typically common with conventional loans and definitely not with cash buyers.
Yeah,
that's all negotiable.
Your FHA lenders are extremely more strict in regard to what's going to occur.
Right. Okay, so then completion of repairs and treatments in 7F, that's when we go through the due diligence period during the option period and we identify that there's been a problem or something that needs to be corrected and we've negotiated a repair, correct?
Right. So turns out your roof has been damaged by hail or what have you. Buyer and seller negotiate. Seller, you need to go ahead and replace this roof. If they in fact don't do that, then 7F is going to allow that buyer to again terminate because they didn't complete the agreed upon repairs.
Okay, 7E and 7F are important about repairs, but how does it relate to section 14?
So 14 is a lot like 7F in that if there were some agreed upon repairs, then they need to get done. 14 is if there's some type of damage to the property during the pendency of the contract, seller has to repair, and if they don't, again, buyer gets to terminate.
Yeah, it was a big issue a couple years ago when we had our deep freeze here in Austin.
Oh,
So it was a problem for a lot of buyers.
lots of files.
All right, so we're going to be in section 9B here, which is called the closing. So this is the date, I guess we're all agreeing upon for the closing date. What's important to this?
So your close date, obviously, both parties have to be ready, willing, and able to close on that date or before that date. And so they can voluntarily agree to close before. If the close date's going to go after that date, then you're going to need an amendment for that.
Okay, so that's the important thing. If you are going to extend the closing date, make sure all parties are notified, put it in writing, get all parties to agree to it so that at the end of the day, everybody is under contract and has agreed to the new close date. If you're closing beforehand, just get your title company. The sellers, the buyers have them all agree to the earlier close date because during the contract it says you can close on or before. Is that correct?
Correct.
Okay. Section 9B1 is the general warranty deed. What does this mean?
So a lot of times a seller may want a special warranty deed, and a special warranty deed limits their risk and exposure some. The TREC 1-4 hard codes in there that they're going to provide a general warranty deed. And so if a buyer said, no, I don't want the special warranty deed in there, we're going to stick with the general warranty deed, seller is refusing, then buyer can terminate based upon that.
Okay, which is important. Can you define what does a general warranty mean?
So a general warranty says that the seller is warranting a good title to that property for the entire history of man, versus a special warranty deed says, since I've owned it, I'll warrant that title. So it increases the risk of the seller when you're using a general versus special.
Okay. Section 12B is called settlement and other expenses. What's important about the settlement expenses here?
So if either party has agreed to pay X dollars, seller is going to pay $500 for a home warranty, or a seller concession of X dollars, or pay some of the closing costs. If the cost for that actual item exceeds what's been agreed to be paid, then that party can terminate the contract based upon that, or the parties can amend, but it does allow that party to terminate if it exceeds it.
This is a very common area that we use, particularly in lieu of repairs. Sometimes the seller may agree, instead of spending time and energy of repairing something, they'll give some money back at closing. This is an example of what that would mean, right?
Yep.
Okay, so let's talk about default. What does section 15 mean?
So 15, the paragraph 15 is going to be a definition of what is default, and if you don't close by close date or et cetera, but then also includes all the remedies that are going to be available to buyer or seller in the event the other party defaults, which is going to be specific performance, forcing the sale of the property, or damages, actual damages, or just taking the earnest money and moving on.
Okay, so it specifically defines if the seller defaults and or if the buyer defaults on this contract, what's going to happen. Very important section, read it and understand it. Then section 19 is representations. What does representations mean?
So if during the pendency of the contracting, you're getting ready to go to closing, seller has said X, Y, or Z exists to the property. So let's say they said there's 2,500 square feet, and you find out through an appraisal or otherwise that there's only 2,200 square feet. Since that representation is no longer true, that buyer can terminate the contract based upon that representation changing.
Okay, and there's a lot of areas to look at where, because all this is knowledge is all available to the public, like the CAD and other areas that you can find information about properties. So you can do your due diligence to make sure that everything's correct and that you're buying what you say you're buying, right?
Yeah, and very, very often there's going to be a different number over at the appraisal district versus the builder versus what the appraiser has said. So you gotta watch.
Okay. Well, I think that concludes our contract. I think we've made it all the way through the negotiation. We've all made it through the execution process. We made it through repairs, all the ins and outs of this contract, and we're at the closing table. And this is exactly what's going to happen when you guys go through the sale or a buy of a house here in the state of Texas. I hope this was very helpful. Again, I'm Keith Milkwoods with Lux Residential Group. This is Alan Ceshker with the Ceshker Group. Thank you for listening, and stay with us next time. We've got something else coming up. This is number 2. We're going to do number 3 in about another month. Take care.